Welcome to now the discussion. David Bruno, he's a criminal defense attorney and former prosecutor in New Jersey. David, I am anxious to hear your thoughts on this really quick verdict, convictions on all counts.
Yeah, look, here's the big difference in the Mosley case than the cases we've recently covered. You had Curtis Reeves, Kyle Rittenhouse, and Brett Hankinson. They all testified, right? And they were all not guilty because when you claim self-defense, you are putting what was in your mind at issue. It needs to be reasonable, objectively reasonable. So not just you, it had to be objective for a reasonable person and also use the same amount of force that's necessary when you're talking about deadly force. So those three defendants that have acquittals that we've recently covered, those are all individuals that took the stand. They were very persuasive in their testimony about why they did what they did. And I believe that was the key to those three acquittals. Now, look at Mosley. Same situation. It's a self-defense argument. There was a lot of video evidence, and they tried to rely on the impeachment of witnesses and the video evidence without putting Mosley on the stand. Now, defendants, they have a right not to testify. And the jury is instructed that the jury cannot use it against the defendants, that it's proof beyond a reasonable doubt that the government or the state has the burden. But oftentimes, when you have self-defense in the case, and that jury is sitting watching this, and two people died, one seriously injured, and you don't go on the stand, and your self-defense is at issue, what was in your mind, it is a very, very tough argument before the jury to find not guilty.
Yeah.
And I think that's the difference that you saw here. Now, I don't know if it would be different if Mosley testified because he had some bad facts in the case, but I will reference those three prior acquittals where the defendants did testify.
Yeah, David, you bring up a great point. It is rare in self-defense cases that the defendant does not take the stand to talk about what he or she was thinking and feeling in those moments to try to prove that. But let's take a moment and watch when Michael Mosley did waive his right to testify.
You understand that you have the right to testify. You also have the right to not testify, and and whether you testify, whether you elect to testify, is a decision for you to make. Do you understand that?
Yes, ma'am.
After talking to your lawyer and after careful consideration of your constitutional rights as it relates to testifying, what is your choice?
I'll waive my right.
He waived his right, David, and if you were representing Michael Mosley, knowing his criminal history, he's currently incarcerated for a vicious assault. We've seen that surveillance video in that Walmart about a year before these murders in Nashville. Maybe that's a lot to overcome. Would you have picked the same strategy?
Yeah, I don't know, because that decision first is Mosley's decision. And you can only arrive in a decision like that with counsel. And I would imagine that that decision was just not made right there. That's a decision that I engage in that conversation very early on with my clients, just to lay the groundwork, explain the constitutional rights. And listen, he does have the constitutional right. The jury can't use it against him. So I think if I put myself into the situation, a lot would have to deal with the numerous conversations that I would have with my client and how confident I would be that he would be a good witness. But ultimately, the buck stops at Mosley, and you saw there what is constitutionally required to put on the record. Because after this conviction, now Mosley cannot say later on in the appeal, well, I should have testified, or I wanted to testify, and I told my lawyer I wanted to testify. That's why the defendants do that little voir dire right there prior to the close of the defendant's case, so that the court has on record the waiver, and it has to be voluntary, and that is what you just saw of the defendant there.
Excellent insights, David Bruno. Glad to have you along for this hour. Stand by. Coming up, we're going to listen to some of the testimony.